The first court hearing is called the arraignment. This usually happens within 24 to 48 hours after you are arrested and taken to jail. At the arraignment, the judge reads the official charges against you. This is the moment when you hear exactly what crime you are being accused of. The judge also informs you about your rights during this hearing. Another important thing that happens at the arraignment is setting the bail. Bail is the money you might have to pay to get released from jail until your trial. The judge decides the amount based on whether you are a flight risk or dangerous to society. Sometimes bail is set low, sometimes high, or it may be denied. If you don't have a lawyer yet, the court may assign a public defender to represent you during the arraignment. This hearing is very important because it starts the formal court process, and you must take it seriously. Always consult a criminal defense attorney before and after this hearing to protect your rights. Charges read during your first court hearing. One of the key moments is when the judge reads the charges against you aloud. This means the court officially informs you of the exact crimes or offenses you are accused of committing. It's important to listen carefully because this tells you what you are being legally held responsible for. The charges come from the criminal complaint or indictment prepared by the police and prosecutors. They include details about the crime and sometimes the evidence the government plans to use against you. The judge will make sure you understand these charges clearly. Hearing the charges can be overwhelming, especially if it's your first time in court. But this step is important because it officially starts the legal process. At this point, you are not required to say anything or admit guilt. You just need to know what you're charged with so you can prepare your defense. Your attorney will review the charges in detail and explain what they mean for your case. If you don't have a lawyer yet, this is the right time to get one to help you understand your rights and options. The charges read at this hearing set the foundation for everything that happens next in your case. Bail set. At your first court hearing, the judge will decide if you can be released from jail before your trial and under what conditions. This decision is called setting bail. Bail is an amount of money or conditions that ensure you return to court for future hearings. The judge considers two main things when setting bail: whether you are a flight risk, meaning you might run away, and whether you pose a danger to society. If the judge believes you will show up to court and are not a danger, bail will likely be set so you can be released. Bail can be set as cash, a percentage of the total amount, or sometimes you can be released on your own recognizance, meaning no money is needed, just your promise to return. If you can't afford bail, a bail bondsman may help by charging a fee to post it for you. Your lawyer can ask the judge to lower your bail or request other release conditions, like drug testing or regular check-ins with a probation officer. Bail is not meant to punish you, but to ensure the court's process works smoothly. If you follow the rules and appear in court, your bail will be returned after your case ends. Attorney appears. One of the important parts of your first court hearing, the arraignment, is when your attorney appears on your behalf. Having an attorney present at this stage is crucial because they help protect your rights and guide you through the complex court process. If you already have a private lawyer, they will come with you to the hearing, speak for you, and start working on your defense. Your attorney will review the charges, discuss bail options with the judge, and explain the next steps of your case. They also ensure that the court follows proper legal procedures and that you understand what is happening. If you don't have a lawyer yet, the judge may appoint a public defender to represent you. Public defenders are experienced attorneys who handle many cases, but they may have limited time to spend on each client. It's important to communicate well with your public defender so they can prepare a strong defense for you. Having an attorney appear for you at the arraignment also means you don't have to speak for yourself unless you want to. Remember, it's common advice to remain silent and only talk through your lawyer to avoid accidentally saying something that might hurt your case. Your lawyer's role at this early stage is to begin building your defense strategy. They will collect information, investigate the circumstances of your case, and look for any errors or weaknesses in the charges against you. They may also start negotiating with prosecutors about bail or possible plea deals. The attorney's presence is not just about the hearing day. It signals the start of a professional relationship where your lawyer advocates for you throughout the whole court process. Whether it's a simple summary offense or a serious felony, having a skilled attorney represent you at every step increases your chances of a better outcome. If you don't have an attorney yet, it's important to find one as soon as possible. Early legal advice can make a big difference in how your case unfolds, and your lawyer can protect you from making costly mistakes during this stressful time. Plea options. At your first court hearing, you will be asked to enter a plea in response to the charges against you. This means you tell the judge whether you plead guilty, not guilty, or no contest. Most people plead not guilty at this stage because it gives your attorney time to review the case, gather evidence, and prepare a defense. Pleading not guilty means you deny the charges and want a trial to prove your innocence. If you decide to plead guilty, you admit to the crime. Sometimes, a plea deal is offered by the prosecutor, which might reduce the charges or the sentence if you agree to plead guilty. Your attorney will explain whether a plea deal is a good option for you. There is also the no contest plea, which means you don't admit guilt but accept punishment. This plea has similar consequences to a guilty plea, but may be used in certain situations. It's very important to discuss your plea options with your lawyer before making a decision. A plea can have long, lasting effects on your record, so don't rush. Next court date. During your first court hearing, the judge will set the date for your next court appearance. This next date is important because it moves your case forward in the legal process. It could be for a preliminary hearing, pre-trial conference, or trial preparation. The judge gives you this date so you know when to come back and continue dealing with your case. Missing a court date can lead to serious problems like a warrant for your arrest, so it is very important to keep track of this date and show up on time. Your attorney will help you prepare for the next hearing by gathering evidence, filing motions, and negotiating with prosecutors. They will explain what will happen at the next court date and what you need to do to get ready. Always keep good communication with your lawyer about your upcoming court dates. Make sure you know where to go and what time to be there. Staying organized and informed can help reduce stress during this difficult time and improve your chances for a positive outcome. Rights explained. At your first court hearing, the judge or your attorney will explain your legal rights. It's very important to understand these rights so you can protect yourself throughout the court process. You have the right to remain silent and not answer questions without your lawyer present. This protects you from accidentally saying something that could be used against you. You also have the right to legal representation. If you cannot afford a private attorney, the court will assign a public defender to help you. Your lawyer will guide you through the case, explain what to expect, and defend your interests. The court will also explain your right to a fair trial, the right to confront witnesses, and the right to appeal if you are convicted. Knowing these rights helps you understand your options and responsibilities. Your attorney will make sure you fully understand the charges and consequences before you make decisions like entering a plea. If you ever feel confused or pressured, ask your lawyer for help. Protecting your rights is the first step toward a better outcome.